Hey guys, it's Christmas. And that means it's time for a gift. So, what I have for you tonight is a little exploration over this trademark thing. And I'm not going to jump into Dick's petition tonight. I mean, I'll allude to a couple parts of it, but I'm not going to go through it tonight. That's going to come very soon. But it would take a really long time. It's got a lot to go through. But what I want to do tonight, just a second. Okay. Sorry. What I want to do tonight is I want to go through a couple trademark basics related to this particular type of filing, okay? Because there are multiple grounds for filing trademarks. There are multiple types of trademarks and uses and all sorts of stuff. But you know, the trademark application is very thorough in what actually this mark is being used for. They actually let Maddox tell us exactly what type of trademark he's going for, what section it's under, and that makes the legal analysis a little bit easier because the Trademark Act is voluminous, right? And there's a lot to go through. It's a highly specialized area of law. And as a disclaimer, I am not a trademark attorney, nor do I want to be a trademark attorney at all. That is not a job for me. I don't want it. No, thank you. But kudos to the guys who do it because they have to know a lot. They have to be very specialized, and that's why they get paid a lot of money. But this particular case doesn't require a ton of specialization to decide based on what we know right now. It's pretty clear that this is an invalid application, and that's not to say. I mean, I think personally that Maddox was very underhanded in applying for this trademark, but legally, and this is important here, because the lull suit is a frivolous action in a lot of ways. It would be very hard for someone to honestly think that they have a claim to what's listed in that. It looks punitive. It looks like they're trying to just take money away from people and feed it into the legal system. So that, there's, I know YouTuber Law has talked about the possibility of sanctions or award for attorney's fees, and I've mentioned it a couple times. I'm not 100% sure how New York handles them, so I'm reluctant to say that there definitely will be those things. I don't know. What I can pretty confidently say in the trademark suit is I would have a hard time saying Maddox is being malicious legally. I think he's being vindictive and a little malicious in his filing of the trademark. I think it's for him, aha, I got you because I did my homework on something and you don't because you're Dick, and Dick doesn't do homework in Maddox's mind, right? We saw this all through The Biggest Problem. He thinks that he's got a grasp on the academics of a subject, and that will give him an advantage. And so I think he's definitely doing this in some malicious and vindictive way, but I don't think he meets the legal standard for malicious or vindictive action under the trademark. I think that all of his claims can be supported as a reasonable attempt to assert ownership of a mark. And it just so happens there's a conflicting party with an ownership interest. But I think Maddox genuinely doesn't believe that Dick has ever had an ownership interest in The Biggest Problem. That doesn't mean that Dick doesn't. And as we go through here, I'll tell you why. And we're going to use a clip of Maddox and his own words to kind of illustrate that point. But I think Maddox genuinely just doesn't understand what a partnership is, what concurrent ownership or what entity ownership looks like. And the fact that they, I'm guessing, never registered an entity or filed any documents, I think Maddox then thinks that there is no entity, but that's not how it works, right? So let's start this up. Let's start it up with the clip. Now I'm going to edit in the clip after this. So for me, no time has passed, but for you, about 3.5 minutes will pass now.
So before we get into the podcast side of stuff, how did you and Dick Masterson meet? How did you come together to develop the podcast, The Biggest Problem in the Universe? And I mean, it's pretty self-explanatory, but what's the podcast about?
Oh, right. Yeah. So The Biggest Problem in the Universe is a podcast where we discuss problems every episode and then have the listener vote on which problem they think is bigger. And then over time, we're going to have a master list of all the problems ranked from biggest to smallest. And so that's
What's the biggest one right now?
The biggest one right now is slacktivism.
Okay, yeah.
Those are people who post things on Facebook like.
But there's apparently no winner every week. Although I think Dick seems to think otherwise.
Dick is a very simple man, and as part of being a simple man, he requires there to be a black and white winner and loser. Mm-hmm. But when it comes down to things like debating two totally disparate topics from different fields of philosophy and different branches of society, how do you compare them in any actual way other than just say what is a bigger problem? That's the only. I think that's the only vector that we can actually compare problems on, is which one is bigger, not which one wins. It's like who wins, which M&M wins, the orange one or the brown one or the yellow one. I don't.
Some might argue that there are certain M&Ms that win. The green M&M is always the winner because it makes people horny, apparently.
Yeah, apparently.
You haven't heard that?
I didn't know that.
Urban legend.
Yeah.
Is that like the same thing that makes you infertile if you drink too much Mountain Dew?
Oh, yeah, Yellow 5. That's another.
It's colors.
Yeah.
So there is a worst soda. It's Mountain Dew because you'll be sterile. So how did you and Dick Masterson meet? How did you form this bond to create the podcast?
Well, we had the same editor for our books, and my editor reached out to me one day, and he's like, "Hey, do you want to meet up with this guy who does this, web analysis or something?" I said, "No, that sounds awful." And then he reached out to me again for some reason. And was like, "Hey, he also wrote this book. You sure you don't want to meet with him?" I'm like, "Okay, whatever. I'll check it out." Yeah. And that was, I think, his Men Are Better Than Women book or whatever.
Yeah, of course.
It's kind of crazy. I'm like, all right. So we met up at this Irish bar, just became bros immediately, and got some beers, and we just started hanging out a bunch, and to the point where I think we lived a block away from each other, and we just hung out all the time.
Yeah.
And we still do. We still drink and hang out all the time. We'd pitched a couple shows. We sold a show to Spike together, and that went down the development hell that is Hollywood.
Yeah.
And then we sold a show to Fox, and again, development is really tough in Hollywood. Shows can be in development for years, and nothing that can ever materialize sometimes. And unfortunately, that was the case with us. So we talked about doing a couple different podcasts, and then one of the concepts of the shows that we were pitching at the time was a show called. We didn't have a name for it, but it was the concept was these guys who fix everything, and I believe Dick more than I was really fixated on that idea. Yeah. It was an idea I borrowed actually from an old improv teacher who did the show called I think the Fix It Men or something like that, where the entire premise of the show is they're working on something that they need to fix, like a washing machine, car engine, or whatever. And so I liked that idea, but wanted to take it bigger and say this could be a genesis of a show where they try to solve all of society's ills. Well, Dick one night was saying he was pitching me different variations of that show.
Yeah.
And finally, I was like, no, what if we don't try to solve the problems? What if we just discuss the problems and then make a big list of them? And I know this sounds like I'm a huge hypocrite because I hate lists.
Yeah.
But that's essentially what this is. It's a big list of all the problems in the universe. And that's how it became the biggest problem in the universe. I thought, okay, well, that's the branding. It's the same branding as my website and everything, so that just makes sense. Yeah.
Okay. So in that clip, we have Maddox saying some pretty important things, and I'm gonna put the YouTube transcript up along with my discussion here. And I've got some relevant parts highlighted that I want to go through. So going back to the beginning of the clip, the question is, how did you and Dick Masterson meet? How did you come together to develop the podcast, The Biggest Problem in the Universe? And I mean, it's pretty self-explanatory what's a podcast about, blah, 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 blah. Now, notice here immediately. Now, this is back in 2015. Okay, so this clip is from the ETC show. It's back in 2015. There's a link to the full video in the description. I've cut out the relevant part to this discussion. And this is back when the show is going. Things are good. Maddox refers to Dick as his bro. They hang out. They get drinks together, stuff like that. So things are going well. So this is an interesting indication because obviously when things are going well, you feel one way. And then when things are not going well, you may feel a different way. And you may change the facts in your own mind. This is a problem that I run into as an attorney, is that, sometimes I have to question my own clients, the validity of what they're saying, not because they're intentionally trying to deceive someone, but because they genuinely have shifted the course of events or certain realities in their mind to protect their own interest. And it's not always a conscious thing. You see this a lot in family law, right? When people are arguing over who gets the kids, suddenly things take on very different tones, and things that didn't bother people before, they suddenly do now. Things that wouldn't scare people become terrifying. The most horrifying events, like, that's how these things go. So what does Maddox say about that? It's telling that immediately Maddox does not assert that the biggest problem is his show and Dick's just on it. He has an opportunity to right away to do that, and he doesn't do that. He goes on just to talk about how he met Dick, and then a couple minutes later, he goes ahead and gets into like what that looked like. And the prompting question for this was, so how did you and Dick Masterson meet? How did you form this bond to create the podcast? And again, the podcast interviewers are operating under the assumption that this is a collaborative work. It appears anyway. I don't know what they're actually thinking, but their words indicate it's a collaborative work. And again, Maddox has an opportunity to correct them and does not. I think it's pretty telling that he does not. He doesn't contradict them because it appears by all accounts to be a collaborative work. And as we go through, we get his own words telling us this exact thing. So just listen to these sections that he spoke about in the clip. We'd pitched a couple shows. We sold a show to Spike together, and that went down the development hell that is Hollywood. We sold a show to Fox, and again, development is really tough in Hollywood, and shows can be in development for years and nothing can ever materialize. Unfortunately, that was the case with us. So we talked about doing a couple different podcasts. And then one of the concepts of the shows we were pitching at the time was a show called, we didn't have a name for it, but it was, I don't actually have the full clip, but he's talking about this show about fixing it, right? About guys fixing problems. And then he goes on with that. Dick was saying he was pitching me through different variations of the show, and finally I was like, what if we don't try to solve the problems? What if we just discuss them and then make it a big list? Everything about this segment says collaboration from before the product existed. So you've got two people discussing this product back and forth. We have no indication from Maddox that he's asserting a single claim of ownership. We have no indication that he thought of Dick as some sort of paid consultant. We have no indication that he is the owner and Dick is like an employee or a contractor. None of that is given. In fact, Maddox uses we primarily. There's one spot at the end of the clip, and I included it for thoroughness, that Maddox asserts anything close to ownership, and he doesn't assert ownership, but he says, that's how it became the biggest problem in the universe. I thought, okay, well, there's the branding, and it's the same branding as my website, right? So he's basically, he's not asserting ownership here, but he could make the argument that he was under the impression that this was his brand, and that since it was his brand, it was his show. That's merely evidence. But the rest of the evidence of this clip points to a collaborative work. Now, how collaborative works in business go? If you don't register anything, you have what's called a common law general partnership. If you have two people contributing to a work that will be a joint venture. Okay, so two people get together and say, hey, we need to open a business, or hey, we need to develop a product and sell it. That, absent something else, looks like a joint venture, and the presumption rests heavily on it being a joint venture, because two people don't get together and say, we need to work on a product that will solely benefit you. That doesn't happen very often. There are sort of agency, I shouldn't say agency, there are like publication relationships, there are production relationships where you go to someone with resources, for example, and say, I want you to create my product because my product will benefit you. You can sell it, and then that will cause monetary gain for you as an investor. I'm the creator of the product, and I just need to use your distribution resources, your capital, those sorts of things, and you pitch it that way. We don't have any indication that that Dick came to Maddox and said, I need to use your fan base to create a product. That may be how it went down. We just don't have any indication that that's how it went down. Maddox doesn't describe it that way, and I don't have the clips of Dick describing their creation of the podcast, but it doesn't come across that way to him, from him either. So neither party asserts that Maddox is the original owner prior to this application, and that's going to be really important as we go on. So we've got the clip. I've gone through the quotes. You're welcome, by the way. I think this clip should be examined, right, by interested parties. I actually think Maddox should examine this clip and consider whether he wants to withdraw his application. Because he's gonna, Maddox, if you're watching, or if one of your minions or lackeys or fans, whatever person may be watching that is sympathetic to Maddox, listen. Trademark disputes go on for years, and they cost tens of thousands of dollars. Do you want to spend that money to lose? Because you're probably going to lose. Look at this clip. This clip is from prior to your trademark. It's closer to the inception date. This evidence of your words, without Dick even present and hardly mentioned, your appearance on this show is likely going to be enough to bury your claim on its own, because everything you say in this document, everything except for that last line in that clip, not a document, everything you say there contradicts your individual claim of ownership of the show. It looks to be a collaborative work. If it's not a collaborative work, you better have some documentation of it, because Dick's description of how it worked out and your description of how it worked out are congruent. That's bad for you, good for Dick. It's going to cost you both a ton of money, and if you're just being vindictive against Dick and trying to get him to spend money, you're being a dummy, because you're going to be spending your own money. It's not a good plan, man. Move on. Move on and go market I don't know if anyone wants to buy another book from you. Sell a show. Go back to updating your webpage. You still got a lot of people who like how you write articles. Anyway, check it out, Maddox. Check out this clip. Watch the whole interview again. Find other interviews of you at the time, because you're going to see a disturbing trend where you bury your own claim by the actual facts, not the modified facts that you have rewritten in your mind, that steel trap brain of yours. Anyway, because yeah, any attorney is who presents this, and that, let me be clear, I don't think they need this clip to bury your claim. I mean, there's just enough evidence on the face of things that Dick has asserted ownership of the show. From the moment the show ended, Dick maintained that he was owner, at least part owner of the venture creating the show, and that he had rights to deal with things. You claim in your lawsuit that he has the biggest problem information stashed on his servers of his company. How would he have that if you have ownership of the material? Also, I'm going to go through these at some point, but the accounting documents that were held by Dick, because he did the accounting in your joint venture, and you guys have an even split of money. Like, how are you going to justify to the court that you're the owner, but you guys split everything evenly, and he shoulders a significant burden in doing the accounting and the bookkeeping? That's going to be a tough thing to do. And why his servers had the information in the first place. Like, if you're asserting ownership of this product, why is the product on his server? Did you have a contractual relationship giving a license to that server, or were you compensating the server holder for holding all this data? I mean, what are you going to do about that? How is your ad revenue split? Those things don't, and I mean, buddy, unless, no, I'm not even going to tell you. You'll figure it out. If you have a valid sole ownership interest, you'll figure out how to get there. But from what we've seen, I don't think you do. And now I'm going to start talking about why. Let's pull up a couple things here. So this is trademark disputes under Section 1 are handled by the Trademark Manual of Examining Procedure, and it's actually Chapter 1200. So let's see. What do we got here? All right. So this is under Section 1B, right? Because if you remember in the previous video, we've got the initial application filing it as under Section 1A, which is the use of an existing mark that's in commerce at the time. And then Maddox filed an amendment switching it to 1B. This is where the mark is a proposed mark, which is a little baffling, except that we can reason that if Maddox shows the mark in commerce, it's going to show Dick as part owner. And I think that's part of the argument fronted by Dick's attorneys. But it doesn't matter what Maddox applied as 1A. I mean, it matters for argumentative purposes for the attorneys, and we'll cover that in Dick's document on the next video. But for our purposes, since it's not filed under 1A, we don't care. It's filed under 1B. So this is Section 1201. This is from the Trademark Manual of Examining Procedure. In a Section 1B application, before the mark can be registered, the applicant must file an amendment to alleged use under 1501C, a statement of use under 1501D, or a statement of use under 1501D, which states that the applicant is the owner of the mark. Okay? This is important. How do we determine who the mark is? Who owns the mark if the applicant is an owner of the mark. So what we're going to do is take a look at that statement under what was it? It was 1501B, right? 1501C and D. Just a second here. Okay, so C and D at any time. So C is at any time during examination of an application filed under subsection B of this section, an applicant who has made the use of the mark in commerce may claim the benefits such use for purposes of this chapter by amending his own application to bring it in conformity with the requirements of subsection A. And then section D that they're talking about is the intent to use the mark within 6 months of the application. But importantly, so this is brought under section 1B. And that's what we're going to focus on here, because this is where we get the definition that is most problematic for Maddox, right? So section 1B, then section 3, the statement shall be verified by the applicant. So I'll just read it all. Sorry. The relevant part is part 3, but let's go to part 1. A person who has a bona fide intention under circumstances showing the good faith of such person to use a trademark in commerce may request registration of its trademark on the principal register hereby, establishing by paying the prescribed fee and filing with the PTO on an application a verified statement in such form as may be prescribed by the director. The application shall include specification of the applicant's domicile and citizenship, the goods in connection with the applicant has a bona fide intention to use the mark, and a drawing of the mark. Okay, Maddox has done all that. But section 3, the statement of the mark shall be verified by the applicant and specify, first, that the applicant is making the verification believes he or she or the juristic person in whose behalf she makes the verification to be entitled to use the mark in commerce. I think I went through this in the last video, but I'm going to go through it again here. B, the applicant's bona fide intention to use the mark in commerce. C, that to the best of the verifier's knowledge and belief, the facts recited in the application are accurate. And most importantly, D, that to the best of the verifier's knowledge and belief, no other person has the right to use such mark in commerce either in the identical form thereof or in such near resemblance thereto as to be likely when used or used or in connection with the goods of another such person to cause confusion or to cause mistake or to deceive. No other person has the right to use the mark. That's what Maddox is saying. And that is, that's a huge problem, because that means that Dick never had the right to use the biggest trademark, or he at some point, or biggest problem in the universe, or he at some point forfeited the right to do so. And if he forfeited that right, you got to show where or how, and it better be in writing. Because if it's just you saying he forfeited the right, and he says, no, I didn't, you got nothing. The presumption will fall on Dick having an equal right. He's asserted the right well, because when you released all the bonus episodes for free, by the way, in violation of your joint venture the common law agreement for your joint venture, when you did that, Dick similarly placed all the material and the content up as well. When you excluded him from the biggest problem domain name, by the way, domain names are specifically not part of the trademark process. A domain name can be enforced under trademark if it violates a trademark, but you taking control of the domain is not asserting your ownership of the mark itself. You're just taking over the domain. So by you excluding Dick from the biggest problem webpage, that domain name, that doesn't assert your trademark ownership. But what Dick did by then publishing on the Dick Show all of the biggest problem episodes, that's asserting ownership of the trademark and the right to use a trademark. And you can try and claim that he didn't have a right to do it, but what basis do you have? Because if it was a joint venture, he has as much right as you do to do so. What he doesn't have a right to do necessarily is interfere with your ability to fulfill some sort of contractual obligation for the show. We don't have any evidence that he did that. And we're going to talk about that in your response, because you assert unclean hands, and I think you have no idea what unclean hands is. But your attorney probably does, and it's what we call the long shot kitchen sink approach, where you throw in anything that's even possible. But let's go on and see what the ramifications of this are. So this is section 1201.02b. And the title says it all. Application void if wrong party identified as applicant. So there's some stuff here, but let's get to the meat of it. Fourth paragraph. In an application under Section 1B or Section 44 of the Trademark Act, which is 15 U.S.C. Section 1051B, the applicant must be entitled to use a mark in commerce on the application filing date, and the application must include a verified statement that the applicant has a bona fide intention to use the mark in commerce. When the person designated at the applicant, this is important, right, was designated as the applicant was not the person with a bona fide intention to use a mark in commerce at the time the application was filed, the application is void. And here's the citation that really sucks for you. American Forest versus Sanders, 15 USPQ, 2nd, 1860 at page 1864. And here's the parenthetical. Holding that an intent to use application filed by an individual was void, where the entity that had a bona fide intention to use the mark in commerce on the application filing date was a partnership composed of the individual applicant and her husband. So, this is a partnership between husband and wife, and one of them filed for ownership of the mark. Not the partnership, right? Just one of them individually did. And that was considered void because the entity owned the mark, not the husband or the wife, right? They own the entity together. Now that's a husband and wife, legally a much stronger relationship than you and Dick have. And many people would argue that what is a wife's is a husband's, what is a husband's is a wife. In some states, that's kind of by law, right? They have a presumption that they have full ownership of each other's property. So in this case, even that is not enough to allow one party to assert ownership over the other, because the mark is owned by the entity, not by one of the parties. And the entity is owned by both parties. So, paragraph 5, when an application is filed in the name of the wrong party, this defect cannot be cured by amendment or assignment. That means it's void. It's done. There's no argument. You lose your right to the trademark, or to assert sole ownership of it, right? You gotta buy Dick out. You gotta buy him out, and he has to be willing to sell. That's what has to happen, or he has to buy you out, and you have to be willing to sell. Like he similarly can't file a trademark claim against you, stating that he's a sole owner. Notice he hasn't done that either. That won't fly because he's not the sole owner, nor are you. So you're not the owner of the company, you're not the owner of the mark. You're not the sole owner of the entity. There's some split. I'm guessing it's 50-50 because I'm betting you guys didn't file any sort of document. So you've got a general partnership 50-50 split, no matter how many snacks you brought. And that's that. The entity has to file, and you guys, then any use of the mark is owned by the entity, and you're bound by that original partnership. You don't get to just decide that you own all of it or he owns all of it. I know you've done that. You've decided that you own all of it and tried to, you made content free that wasn't free and stuff like that. But, and you took the RSS feed. That those actions weren't okay. But they're done. They're in the past. Nothing we can do about that now, right? Now, you may decide, Maddox, that you have another argument. You may say that this is a use by a related company and that you have the interest in the company. But let's look at that real quick. And this is less impactful. I don't think in my review of your answer that you have asserted this as a defense. So I just want to cover it for thoroughness. So this is 1201.03. And in relevant parts, the term related company means any person whose use of mark is controlled by the owner of the mark with respect to the nature and quality of goods or services or in connection with which the mark is used. So your argument would be that you own the biggest problem in the universe. But since you don't have a document showing that you own the biggest problem in the universe, because if you did, I assume you would have filed it with your answer. Since you don't appear to have that document, then you have to provide, you have to show that you have control over the nature and quality of goods and services. And more importantly, the benefit of using that related company has to inure to you solely. You're going to have a real problem showing that because we have the accounting documents, and unless you assert that they're false, which would be tough because bank statements will verify any of these deposits, but unless you assert that they're false, the accounting documents show that the use of the trademark by the entity inured to both of you, not just to you, right? It didn't inure to you, it inured to you and Dick. Both of you got benefit from using the mark. So the next relevant part. The essence of related company use is a control exercised over the nature and quality of the goods and services on or in connection with the mark with which the mark is used. When a mark is used by a related company, use of the mark inures to the benefit of the party who controls the nature and quality of the goods or services. This party is the owner of the mark and therefore the only party who may apply to register the mark. But it doesn't inure to you. It inures to the entity, right? The illusion, the non-registered but common law partnership that owns biggest problem, whatever it is, Masterson and Maddox Incorporated, Masterson Azunian, whatever you want to call yourself. I don't care. Dick and Maddox, Dick and George. Pick your poison, man. The entity is getting the benefit, not you. You're getting benefit from your ownership interest in the entity, not your ownership interest in the mark. The entity owns the mark. Over and over, this is going to be the case. This is what you're up against. And until you file some document, some proof that you own the mark outright, or that you own the entity outright, and Dick is a non-interested party, you gotta... you don't have an uphill battle. You have no battle. You have lost, and your application is void. And I think that's what's going to happen to you really possibly quickly. I mean, you can file all sorts of counter motions, and you guys can go through discovery. You're going to burn a ton of money on this. It's not worth it. So my Christmas gift to you, Maddox, I'm going to save you like $25,000 to $30,000. Drop the suit. Drop the trademark dispute. Dick can't file a trademark. He can't take it from you, right? It's a co-ownership. It's a partnership. Move on. Move on. There's no reason for you to use the biggest problem anymore. It was a joint venture. You lost it. Both of you guys made decisions I'm sure both of you regret in some way. One of you probably regrets them more than others because one of you lost more than the other. But you lost it, man. It's gone. So my Christmas gift to you, who else, Maddox, who else of your friends gave you $25,000 to $30,000 for Christmas but me, a humble man on the internet? Giving you 5 figures. Drop the trademark suit. You should drop the other suit too before you get just... It doesn't even matter if Dick's lawyers do it. Weber Shandwick and Patreon's lawyers are going to nail you to the wall. And you're going to lose money. Potentially large amounts of money. I mean, if nothing else, you're paying your hack attorney who is not doing a proper job. If he's doing the work at all, it's not a proper job. Drop the trademark suit for sure. Trademarks cost too much. A trademark suit in general costs more than the biggest problem is probably worth. And we're talking about one of the more successful comedy podcasts ever made. But the IP of the biggest problem probably costs less than the trademark suit you're going to fight to defend it. So there's... Merry Christmas, my man. Drop the suit. Drop it. it's going to be embarrassing also. It's going to be really embarrassing when you lose. Unless you've got some serious ace in the hole. And if your attorney tells you that some sort of email between you and someone else, unless it's a signed document by Dick Masterson saying, I give you full control of the company, I mean, he might just be trying to get your fees, buddy. There's a lot of money for him to make here. Aren't you the guy who like you didn't want ads on your site because you didn't want to be compromised by money? Oh my gosh. Attorneys are compromised by money by nature. We're the person giving you advice to keep going in a suit that will pay us tens of thousands of dollars. Think about that. Think about that. Your attorney is your friend so long as you pay him, pal. Like that's the reality of our relationship. And it's a weird thing. It's allowed, right? It's allowed. But you've got to be skeptical of how much this property is worth to you, because it's worth a lot to your attorney. It's worth a fortune. And the harder Dick fights, the better your attorney gets paid, right? Maddox, drop the suit. Merry Christmas, Happy Kwanzaa, Happy Hanukkah, whatever your poison, man. I don't care. I'm giving you the best gift anyone can give you. Drop the suit. I'll save you a ton of money. Start a new project and move on. As for everybody else, my personal fans, my gift to you, unfortunately, I only have $25,000 to $30,000 to give to Maddox, which I know seems a little rude to you guys. But I give you the gift of the video clip, which was not my find at all. And I apologize right now. I don't have who provided that to me, and I don't know if they want their name out on Facebook. You know who you are. Thanks for sending me the clip, and yeah, my gift to you guys is just this wonderful idea that Maddox will sink his own case with his own words in an interview from 2015 before he decided to change the entire script, and everything was going well and everybody was happy and making money. So good luck, Dick. Merry Christmas to you all. If you're curious, this is Lagavulin 12 again. It's Christmas Day. Gotta have a special extra kick liquor tonight. You guys have a wonderful Christmas. If you don't have family to spend it with, go find a homeless person and hang out with them. Have a good night, y'all.